Okay, guys, so today we are going to take a small topic. If you listen carefully, you'll understand what this topic is essentially all about. So, we have covered both rights and duties. Uh, the third topic is obligations, law of obligations. Now, we are not going to go into details of every law of obligation, as you are probably already studying some of those papers. For example, law of tort, contract, etc. So, law of obligation is basically the jurisprudential base for all these subjects. Okay. So, obligations in our common understanding, we interchangeably use it with duty. So, when we say someone has a duty to do something, we also understand it as someone having obligation to do something. Well, that's what the lay understanding of the term is. Obligation, in fact, implies a kind of duty. So, in general, it is synonymous with the word duty. However, as we understand in jurisprudence, on a stricter sense, uh, there are certain differences that we need to understand. Okay, so on stricter sense, obligations are those duties. Okay, only those duties whose correlatives are rights in personam. Now, if you remember, the other day we made this distinction between right in rem and rights in personam. Okay, so when we talk about obligation, it falls strictly under the second category, that is rights in personam. Okay, now one more thing that I would like to add. Okay, we made this distinction between proprietary right as well as personal rights. Okay, so obligation is a proprietary right in personam. So if that categorization of rights, okay, as we did the other day in the last class, was clear to you, then you will understand what obligations are. Obligations are proprietary rights. Okay, it's not property though, because property we understand as right in rem. Okay, so it's proprietary right, but in personam. So now obligation has to be understood in totality. Okay, so obligation is not to be understood only in terms of it being a kind of duty. Okay, it implies a vinculum juris. Okay, it implies a vinculum juris, or known as bond of legal necessity. So it creates a bond of legal necessity which binds two or more determinate individuals, okay, or you can say two parties together. Okay, it binds together two or more determinate individuals. Okay, so that's what obligations are all about. It's a proprietary right in personam. On the other correlative side, there will be a duty as well, proprietary duty here in personam. So that's what obligations are. It's a proprietary right, not personal right. Okay, and it is right in personam that binds two determinate individuals together through a vinculum juris or bond of legal necessity. So, as you know, when we talk about proprietary right in personam, okay, it is not all rights in personam though, something that you remember. Now, rights could be either negative or it could be positive. Now, negative right requires inaction. Now, inaction in itself does not have much, proprietary value. So when we talk about obligations, these are proprietary rights in personam, okay, but these personam rights are positive in nature. So something is owed to you, some money is owed to you, judgment, there is a judgment debt, okay. So something is owed to you and it has proprietary value. If it is like that, then it is about obligations. So some examples would probably make it clear to you. Let's take the first example. So someone owes certain money to you. A debt is owed to you. There's a duty to pay the debt. Okay, and you have a proprietary right in personam that the duty is paid to you. Okay, so there are two parties. There's a vinculum juris and it's the money that is owed. It's not a right in rem, it's a right in personam between two determinate parties. Okay, and secondly, it is a positive right because the duty would be to pay the money. Okay, so that's a case of obligation. There could be other examples. So for example, a tenant stays in a room, okay, and the tenant has to pay rent. Okay, so there is a obligation here as well, the duty to pay rent. That is a specific that is an obligation, case of obligation. It's a proprietary right in personam, and the right is positive in nature. Similarly, if there is a duty to perform contract, or under law of tort, if there is a duty to pay damages, okay, so those are proprietary rights in personam and are positive in nature, and all these fall within the law of obligation. So you can say the law of tort, contract broadly fall within the law of obligation. However, if it is with respect to property, things, okay, then you know that it's a case of right in rem. So that will be a different kind of right. So obligations are proprietary rights in personam, and the right is positive in nature. That means the duty is positive. That is duty to do something, duty to pay debt, etc., etc. Complete, fulfill the terms and obligations related to contract, etc., etc. So, as I was telling you, the term obligation is not to be understood only from the perspective of duty, but also to be looked at the totality. So that would include the vinculum juris as well as the correlative right. The totality is the idea of obligation. So from the perspective of the person entitled, okay, the obligation would be a case of, right, and from the perspective of the person bound, okay, it is an example of a duty, a kind of duty, not all duty though, you remember. So it is this totality, this entirety of this relation, along with this vinculum juris, that is bond of legal necessity, the totality constitutes obligation. The person entitled to the benefit of the obligation is known as the creditor, and the person who is bound is known as debitor. And they are related to the sphere of proprietary rights of a person. So it is a proprietary right. So once more, remember, it is a proprietary right. Okay, it is not a personal right. However, it is not a right with respect to thing, okay, or property. So it is a proprietary right in personam, and the right is positive right. That means the duty correlated is a duty to do something, duty to pay debt, duty to fulfill contract. So that's what this idea of obligation is all about. You can also roughly equate it with something known as shows in action. Now in England, there's this shows, you can understand it as things, okay. So in England, there is this distinction, that is made. One is about shows in possession, and the other one is shows in action, okay. What's the difference between these two? You can say that shows in action is a proprietary right in personam. So when you have a right of action, okay, so if a debt is owed to you, if you have money in the bank, etc., etc., in such case, you can enforce these rights through an action, okay, as opposed to other kinds of, shows where you can take possession of things in order to fulfill the rights, okay, fulfill your rights. As opposed to that, in case of shows in action, it is an action that it is a lawsuit that we are concerned about, okay. So shows in actions are examples of proprietary right in personam. So there could be many such examples. I gave you two already. So if a debt is owed to you, if there is a share in the joint stock company, or if there are claims for damages in case of tort, so all those, or if you have money in your account, all those would be examples of shows in action, broadly known as proprietary right in personam. You can also equate them then with obligation. So that means that non-proprietary right in personam does not come within the meaning of obligation. So Non-proprietary right would be basically all the personal rights, rights related to your status, etc. All those would come within the meaning of non-proprietary right. So non-proprietary right in personam do not come within the meaning of obligation. Only proprietary rights in personam come within the meaning of obligation. Now that's the idea of obligation. Now there is one more topic. I mean, the topic is if you look at the syllabus, you will see that there are certain portions which are not really relevant for you because they represent more of like this English law as it exists in England. Okay, so I will discuss only the portion which is relevant for you. You know, as students studying Indian law. So these concepts are relevant for you from that perspective. So if the idea of obligations are clear, let's then proceed to the next important topic within this discussion. And what is that? That's the topic related to solidary obligations. Now, what is a solidary obligation? So generally, in normal cases, okay, you have one debtor and one creditor, okay. So I am owed certain money. So I'm the creditor, the person who owes me is the debitor or debtor. However, it is also possible that there are two debitors and there are two creditors. So that is also a possibility. If there are multiple creditors, the problem is not really that serious. But when the confusions arise when there are multiple debtors. Now the problem is with respect to how the debt is to be shared among these debtors. Okay. So there could be many such examples when there could be multiple debtors. Okay. What are those? So for example, when it comes to firm, you know that a firm is not like a corporation. They do not have separate legal personality. Okay. So when you talk about a firm, it is a firm of different partners. Okay. So debts which are owed by a firm of partners, okay, will be examples of solidary obligation. Why is that? Because the debt is not owed by a separate entity known as the partnership firm. No, it is owed by all the partners. Okay. Not proportionately, but in solidum. Okay, so all of them owe the entire amount to the creditor. So that's an example of a solidary obligation. There could be other examples as well. So for example, debts which are owed by principal debtor, okay, and guaranteed by one or more sureties. What could that be? So for example, if I borrowed some money from A, okay, and that is secured by certain sureties. So for example, when you borrow money from bank, then you have sureties there as well. Okay, in such case, the sureties, okay, one or more sureties, along with the principal debtor, together they have solidary obligation. Similarly, when we talk about joint tortfeasors, okay, when two or more persons commit tort together, they have solidary obligation because they are liable in solidum. So in all these cases, in these three examples that I talked about just now, I said that they are liable in solidum, not pro parte. That means they are not liable proportionately, okay, to a certain extent. They are all liable for the entire amount. Okay. What does that mean? So are in these cases the debts to be divided among the debtors, or are they individually liable for the entire amount? So as I said, they're all liable in solidum, not proportionately. That means they're all individually liable for the entire amount owed. Okay. It's not that if rupees 100 is owed and there are 5 partners that each partner owes only 20 rupees. No, each of them owe 100. Okay. So that means if one is paid, the debt is definitely paid. That's done. Okay. That's what solidary obligation is. As long as the debt is paid, well, that's it we are concerned about. So these will be examples of solidary obligation, and each of these debtors in the examples that we discussed about, they all are bound in solidum. Okay, so they all have to pay, okay, the entire amount, not proportionately. So their obligation is not pro parte but in solidum. So they are all individually liable for the entire amount. So that's your solidary obligation. Now you will see that in the next portion they discuss about different kinds of solidary obligations. So for example, several solidary obligation, joint solidary obligation, joint and several obligation. Now I'm not going to talk about this from Salmon's take, because Salmon is talking about the English law. However, in India you will find that we have these three concepts known as joint liability, several liability, and then joint and several liability. So joint liabilities would purely come within the meaning of this topic that we are discussing about, that is solidary obligation. So for example, if husband and wife borrows certain amount of money, certain loan from a bank, okay, they are both jointly liable. That means if the for example, after they borrowed, if the husband dies, the wife is liable for the entire amount, not proportionately. So that will be an example of a joint liability. Now there could be also examples of several liability. Now several liability is not a case of solidary obligation though. Why is it? Because when we talk about several liability, each of the individuals who borrow the money, by virtue of the agreement itself, they are liable only to the extent that they have signed up for. Okay, so in those cases there will be several liability. Each of the individuals will be liable only to the extent that they have borrowed the money. And then there are examples of joint and several liability. And what are those? So these are those examples, okay, where it is a joint, it has features of both joint as well as several liability. And how is that? So what happens is that law for some purposes treats them as jointly liable, whereas for certain others they are treated as severally liable. Now what does that mean? That essentially means that so let's take example of partnership firm. Okay, they borrow money. So suppose there are 5 partners, they borrow 500 rupees. Okay, and the principle of joint liability says that the creditor can approach each of the individuals. Okay, can say that, well, can go after one partner and then realize the entire debt. So suppose the creditor realizes the entire 500 rupees from one of the partners. So obviously that's what joint liability is all about. They don't have to go proportionately, no such necessity. Now that's an example of joint liability. Then what about the other aspect? Now what happens is that this is something that evolved out of law of equity. Okay. Now what happens is that the other partners, the one partner who had to pay the entire amount, can now realize proportionately from the other partners who also owed the money. Okay, so that's why it is it is case of joint liability, because the creditor could have realized the entire amount from either of these partners. But once that's done, now the one of the partners who paid the entire amount can realize proportionately from all the other partners. So after that, it is an example of several liability. So these are the cases of joint liability, several liability, and joint and several liability. Now this is not to be understood in terms of solidary obligation, because the solidary obligation, you can say that the example of joint liability is a clear case of solidary obligation, even the joint and several, whereas several liability is not a case of solidary obligation, because there are several vinculum juris, and one paying does not relieve the other. So if one paying the debt would have relieved all the other, then you would see that it's the case of solidary obligation. So several liability is not a case of solidary obligation. So yeah, that's it. I think for a conceptual topic related to solidary obligation, this should suffice for you. But there are more important topics, and I think in the next class I'm going to deal in detail with all those other topics. So in the next class I'm going to start with law relating to persons. So that's it from me for today. Thank you.